Hello, my name's Robin Furby. I run a business called Section 106 Management. The main purpose of our business is to advise people on Section 106 obligations. There are two types of obligations broadly. There's affordable housing, and then there are infrastructure requirements such as education, leisure, etc. The purpose of this video is to talk about affordable housing. All local authorities have affordable housing policies. They vary somewhat in their threshold, in that in places like Enfield and Merton the threshold is one house above which you have to make a cash contribution. Then there are other authorities such as Kingston and Richmond, and much further afield where the threshold can be 5, 10 or 15 units. It doesn't really matter what the threshold is. The same policy considerations and research has gone into making the policies, and that creates the opportunity to minimise your obligations. You have to understand that all these policies have been evolved from the idea that when you get planning permission there's a huge uplift in value. Now that's obviously going to be the case where you've got a farmer's field that you have suddenly permission to build a large number of houses on. Of course there'll be a huge uplift in value, and in those circumstances the policies work and it's appropriate for affordable housing to be provided as long as the infrastructure requirements are not too great. However, for many small developers, their development site is not like that at all. It can be a house that's being turned into flats, a petrol station being knocked down, an office block being converted, a house being knocked down and a number of houses being provided in its place. In those circumstances, the existing use value of the house is really significant, and therefore the uplift in value achieved on getting planning permission is much smaller. And it's in these scenarios that we are particularly able to help. Our process involves looking at the whole project. We look at the end value of the site once it's built. From that we deduct the costs of building it, architects' fees, interest, contingencies, everything we can think of. We get left with a figure called the residual value, and we compare the residual value to the existing use value of the property. If the residual value is below the existing use value of the property, broadly speaking, it's not going to be possible to make a contribution towards affordable housing. In many cases, we have a kind of halfway house where the residual value does exceed the existing use value, but not to the extent anticipated by the policy of the local authority. And in those circumstances, we will aim to negotiate a fair settlement with the local authority. So, for instance, you might be building a block of 15 flats. The local authority might be saying that they want 7 of those flats to be affordable houses. If we look at the numbers, we might come to the conclusion that there is in fact perhaps £50,000 as a kind of super profit, and that would be the limit of your contribution. So it's not an all or nothing process. Sometimes we can completely eliminate the affordable housing, and sometimes we end up with a negotiated solution. If you look at your local authority website, you might well find that their affordable housing policy is set out in very robust terms. That's an impression often reinforced by planning officers. The reality is that because of the provisions of Section 173 of the National Planning Policy Framework, all affordable housing policies are subject to viability. So therefore, pretty much every occasion where there's an existing use value, we're going to be able to help you. The standard procedure is that we prepare a viability report for you. That should go into the local authority along with your planning application. Local authorities tend to get a bit cross if you wait till the very last moment before putting it in. Once the local authority have the viability report, they will either send it to an internal consultant or to external consultants for vetting. Very often you have to pay for that process, which is annoying, but really seemingly an unavoidable process. Once the external consultant has looked at the report, there's normally a period of negotiation, which leads to a settlement. This then feeds back into the Section 106 or unilateral undertaking that you will be asked to enter into before the planning permission is issued. We can help there as well if necessary, and it's quite important sometimes to maintain some continuity between the planning department and the legal department so that you don't have the planning department saying one thing and the legal department saying another thing. It's important for small developers to realise that while this sounds like a very confrontational process, it isn't at all. The big house builders, Persimmon Homes, Barratt, etc., have been carrying out these negotiations for years, and it's all a bit under the radar. No one draws any attention to it, but it goes on. Therefore, what we're doing is bringing to the small and medium-sized developer the type of service that the really large developers already utilise. If you'd like to find out more about our business, please have a look at our website or give us a ring on the telephone number that appears at the bottom right-hand corner of the screen. Thank you for listening.